perfectionists, welcome back. As every tort student learns, a plaintiff must establish 4 elements to recover on a cause of action for negligence: duty, breach, causation, and damages. The second element, breach, is synonymous with negligence, or the failure to live up to the standard of due care. This practice-perfect review will describe a number of methods a plaintiff may use to prove that the defendant breached the standard of due care or was negligent. For simplicity, I will speak in terms of a plaintiff proving a defendant's negligence. But keep in mind that a defendant may use exactly the same methods to prove that a plaintiff was negligent, which is an issue in many negligence cases. Let's start by listing the various methods of proof that the plaintiff might use to establish breach of the duty of due care. These include the defendant's violation of a relevant safety statute, the mystic doctrine of res ipsa loquitur, direct testimony as to defendant's conduct, circumstantial evidence of defendant's conduct, expert testimony, violation of an employer's work rules, failure to follow customary practice in a trade or industry, and notoriously, the hand formula approach to assessing negligence. Because there are so many ways to prove breach, Practice Perfect has divided them into 4 separate reviews, with this review focusing on circumstantial evidence, witness testimony, and custom. Of course, it is always appropriate and persuasive to use the direct testimony of witnesses to establish the defendant's negligence. If the plaintiff's witnesses will testify that the defendant ran the red light at the time of the accident, that is powerful evidence of a defendant's negligence, usually the most powerful. Similarly, if a witness saw a mechanic leave several lug nuts off a wheel after changing the plaintiff's tire, that testimony, if believed, will very likely persuade a jury that the mechanic was negligent in causing the tire to fall off. Often, though, circumstantial evidence can be very persuasive in establishing negligence. Circumstantial evidence is evidence of one fact from which the jury can infer another fact that the party needs to prove. For example, the plaintiff might submit evidence of backhoe tracks in his garden to prove that a contractor working in the yard had negligently backed into the garden. Or she might offer evidence of 60-foot skid marks in the road to show that the defendant had been driving far over the 20-mile-per-hour speed limit before she hit the plaintiff. Such evidence can be very powerful indeed. As Dean Prosser famously declared, a jury might believe a set of footprints in the snow against the testimony of 100 witnesses that no one had passed by. Another example of proof by circumstantial evidence would be testimony about the body damage to a car to establish how a collision told witnesses that no one had indeed. As Dean Prosser famously declared, a jury might believe a set of footprints in the snow against the testimony of 100 witnesses that no one had passed by. Another example of proof by circumstantial evidence would be testimony about the body damage to a car to establish how a collision took place. If the damage is to the side of the plaintiff's car, it will be hard for the defendant to argue that the plaintiff ran into him. Another way to prove negligence is to show that an employee violated the work rules of his employer. Suppose, for example, that a railroad sets speed limits for different sections of its track, varying according to the condition of each section. And the evidence shows that the engineer, Munger, caused an accident while going 40 miles per hour along a section of track where the company work rules called for 25 miles per hour. Now, company work rules are not like statutes. They are imposed for the company's convenience, not by a legislative body for the safety of the public. Courts, therefore, will not give them negligence per se effect. But courts do regard such work rules as relevant evidence about what due care requires. So the plaintiff in this case could submit proof of the railroad speed limit at trial and argue to the jury that Munger was negligent for disregarding that limit. This evidence would not require the jury to find Munger negligent, but it very well might persuade them that he was. Another common approach to proving a defendant's negligence is to introduce evidence that the defendant did not take a precaution that is customarily used in a trade or business. Suppose, for example, that most roofers use a safety harness when they are working on a steep roof, but that Jones did not, and he fell off the roof on top of Stern, injuring her. Stern will argue that Jones was negligent for failing to do what most roofers do in the same situation. The argument is, if it is the usual practice in the roofing trade, it is the reasonable way to work on a roof, and failure to follow that practice constitutes some evidence of negligence for the jury to consider. Most courts approach proof of customary practice the same way that they treat violation of employer work rules. The plaintiff may introduce evidence of what is usually done and argue that the defendant was negligent for failing to do what is customary, but this evidence will not automatically establish that the defendant was negligent. Note that the plaintiff cannot try to prove that the defendant was negligent for violating any custom of the industry. The custom must be one that is relevant to the type of risk that injured the plaintiff. If the custom of wearing a full face shield was meant to prevent welders from being hit in the face by hot metal, and that happens to an unshielded welder, then her violation of the custom is useful evidence to show negligence. But if the unshielded welder cut her face because she tripped over a tool negligently left on the floor, not from flying bits of metal, then while she violated a custom, it will not be considered relevant to the type of risk that injured her. It might be that the defendant did something that showed a greater care than the general practice. Suppose, for example, that most lobstermen don't install a GPS system in their boats. Their custom is to rely on their knowledge of the area to keep away from rocks. If the defendant installed a GPS system, he may have been more careful than the other fishermen, not less careful. Perhaps other fishermen have been more interested in controlling costs than in being careful to prevent accidents. So it remains for the jury to consider what the custom is, what the defendant did, and all other relevant evidence in deciding whether the defendant breached the duty of due care. As Judge Learned Hand famously declared in the T.J. Hooper, in most cases reasonable prudence is common prudence, but strictly it is never its measure. A whole calling may have unduly lagged in the adoption of new and available devices. Many tort cases arise from complicated and technical activities that ordinary people like jurors don't engage in and don't understand. Regular people don't program the software for a stock trading program, design the structural engineering for a skyscraper, or conduct spinal surgery. When tort cases arise in the conduct of activities like these, ordinary jurors cannot decide what ordinary care requires based on their own experience. In such cases, the jurors have to be educated by the parties about what due care entails. The parties will offer expert testimony to assist the jurors in evaluating the reasonableness of the defendant's conduct. The plaintiff's expert will explain what was required in the circumstances and offer an opinion that the defendant failed to act appropriately in light of those circumstances. The defendant's expert will disagree, concluding that the defendant exercised due care and explaining her reasoning for that conclusion. The jury will listen to their explanations for those opinions, consider the lawyer's cross-examination of opposing experts, and they will determine whether due care was exercised or not. This is a daunting task and a real challenge to the jury in specialized, highly technical cases. Very likely, the jury's judgment will be based as much on their assessment of the credibility of the experts as it will be on their technical grasp of the details. This concludes our Practice Perfect review on proving negligence through circumstantial evidence, witness testimony, and custom. We recommend you apply your newfound knowledge